Ryan's office revenge. They terminated my employment at 4:23 p.m. on a Thursday afternoon for what Karen Turner called persistent attitude issues. Not performance problems, not policy violations, not any kind of measurable misconduct. Attitude issues. I'm Harold Phillips, 54 years old, and I had just spent 24 years building my career at Apex Strategic Solutions. Started as a junior analyst back when I was 30, worked my way up to Senior Director of Client Relations. 4 National Excellence Awards on my wall. Generated $8.7 million in new business partnerships just last fiscal year alone. But according to corporate leadership, my attitude needed immediate correction through termination. The meeting lasted exactly 12 minutes. Karen sat behind her glass desk with Dennis Coleman from Human Resources next to her, tablet ready to document every word. "We're ending your employment relationship effective immediately," Karen announced in that tone you hear from automated phone systems. "You'll sign these separation documents and turn in all company property before leaving today." She pushed a manila folder across her desk toward me. Inside were 7 different documents, each one representing what they thought would be my quiet acceptance of getting fired. Termination notice, final paycheck acknowledgement, company property checklist, confidentiality agreement, non-compete clause, liability waiver, and the comprehensive release. That last one where I'd supposedly give up all legal claims against Apex Strategic Solutions in exchange for absolutely nothing beyond my earned wages. I looked through each page carefully. Dennis shifted in his chair 3 times while I read. Karen checked her phone twice, clearly expecting this whole thing to wrap up fast. They wanted me processed and out of there before the executive floor emptied for the evening, before I could talk to other department heads about what was really happening behind closed doors. What neither of them understood was that I'd been, methodically, preparing for exactly this situation for 11 weeks. Ever since Eugene Parker took over as CEO and immediately announced that anyone over 45 represented legacy overhead that needed elimination. Ever since he started recruiting 26-year-olds fresh out of grad school who'd accept half my salary and work twice my hours without questioning his questionable business decisions. Ever since I overheard him telling Karen during a budget meeting that my salary could fund 5 junior associates who wouldn't challenge his authority. At 54, with my daughter heading to college next year and retirement still 13 years away, I couldn't afford to just walk away quietly. Barbara and I had been saving for Sarah's tuition, but even with our planning, losing my income would devastate our finances. This wasn't just about my pride, it was about my family's future. So I took action. Invested $11,500 in consultations with an employment attorney named Linda Martinez, who specialized in wrongful termination cases. That money hurt our budget, but Barbara supported the decision completely. "If they want to play games with our livelihood," she said, "let's make sure we know the rules better than they do." Linda and I did a complete review of my employment agreement from 2017 when I got promoted to senior director. That contract had very specific provisions, protections I'd negotiated when Apex was desperate to keep me after their main competitor offered me 35% more money. Back then, I was bringing in major clients and they knew it. Protections they'd completely forgotten about. Protections that were about 7 minutes away from costing them way more than my annual salary. I signed the first document without hesitation termination notice. Acknowledging my employment ended today. Signed the second form confirming my final paycheck would be processed normally. Signed the third document listing company property to return, laptop, phone, building access card, client database codes. Then I reached the confidentiality agreement, the standard non-disclosure document preventing me from discussing proprietary business information. Except this particular agreement wasn't standard anymore. Not after the modifications I'd made 6 months earlier. During a routine contract review, Human Resources had sent updated confidentiality agreements to all executive staff. Standard procedure, they said. Just modernizing language to meet current regulatory standards. Sign and return within 3 weeks. Most executives signed immediately without detailed review. I didn't. I brought that confidentiality agreement to Linda Martinez, had her analyze it completely, and discovered 6 ambiguous provisions that could be interpreted multiple ways under state employment law, so I made subtle modifications. Nothing obviously different, just minor adjustments to section numbers, additional language, footnotes, cross-references to my employment contract that HR wouldn't notice unless they did a word-by-word comparison with legal counsel present. Then I submitted my signed version. Human Resources filed it without checking. Why would they examine it carefully? I was a senior director, not a lawyer. They assumed I'd signed exactly what they sent. They never verified that the document I returned was identical to what they distributed. That was their first critical mistake. Their second mistake was terminating me without documented justification. Their third mistake was about to become extraordinarily expensive. I signed the confidentiality agreement, the modified version that had been sitting in my personnel file for 6 months. Then I moved to the comprehensive release, the document where I supposedly waived all legal claims. Except I'd added one carefully crafted sentence in the signature section, small print, page 5, subsection 3. Easy to miss if you weren't specifically looking for it. Upon involuntary termination without documented justification per company policy, employee signature on this agreement constitutes acceptance of separation. Compensation outlined in employment agreement dated April 19, 2017, Addendum F, sections 4 to 9. Nobody read it, not Dennis, not Karen. They just watched me sign and breathed a sigh of relief that I wasn't making trouble or demanding explanations. I handed the folder back to Dennis, placed my laptop, phone, and access card on Karen's desk, stood up and shook both their hands professionally. "Thanks for the opportunity," I said calmly. "This has been educational." Then I left Apex Strategic Solutions at 4:35 p.m., with my professional dignity intact and a legal mechanism activated that they'd discover in about 4 hours. The drive home took 45 minutes through rush hour traffic. I wasn't frustrated. I had nowhere urgent to be, no client meetings to attend, no project deadlines to meet. For the first time in 24 years, my evening was completely free of work obligations. I stopped at a good market and bought ingredients for an actual home-cooked meal instead of my usual takeout. When I got home, I started making dinner properly. My wife Barbara arrived at 6:30, surprised to find me in our kitchen making grilled chicken with roasted vegetables from scratch. "You're home early," she observed, setting down her purse. "I got terminated today," I told her while checking the grill temperature for attitude issues. She froze in the doorway, her expression shifting from confusion to concern. "Are you okay?" "I'm great," I replied, flipping the chicken. "Just wait. This situation gets a lot better." Barbara knew about the legal preparation, of course. We'd discussed every step over the past 11 weeks. She'd been the one encouraging me to fight back when I first started worrying about Eugene Parker's modernization plans. "Harold," she'd said, "you've given them 24 years of your life. If they want to throw that away, make them pay for it properly." We were halfway through dinner when my phone rang. Unknown number. I answered on the 4th ring. "Harold Phillips?" a man's voice said, tension obvious in every word. "This is Arthur Cooper, General Counsel for Apex Strategic Solutions." My grip tightened slightly on my wine glass. Right on schedule. "Mr. Phillips," he continued, words coming quickly, "I need to discuss the documents you signed today." "The termination documents?" I replied, keeping my tone neutral. What about them? Silence. Papers rustling in the background. There's specific language in the signature section on page 5, subsection 3 of the comprehensive release, he said, voice strained. Did you review that language before signing? I reviewed every single page, I said calmly. That's why I signed it. The silence that followed was profound. I could hear him breathing, but no words. Then, in a voice much smaller than you'd expect from a company's chief legal officer, he said, "Please tell me you haven't signed the confidentiality agreement yet." I signed everything HR provided, I responded. All termination documents, complete package. His voice cracked slightly. Everything? All documents? Yes, all documents, I confirmed. Why is there a problem? Another pause, longer this time. More rustling. Someone else speaking urgently in the background. Then Cooper returned, his voice now carrying a tremor. Mr. Phillips, I need you to read me the exact language from the signature section of the comprehensive release you signed. I pulled out the photo I'd taken of the document before signing, though I'd memorized every word. Upon involuntary termination without documented justification per company policy, employee signature on this agreement constitutes acceptance of separation compensation outlined in Employment Agreement dated April 19, 2017. Addendum F, Sections 4 to 9. I read slowly and clearly. The silence was deafening. I could hear him breathing, but no words came. Finally, he spoke, voice barely above a whisper. And what does Addendum F specify? Minimum 3 years base compensation plus all accrued benefits. Immediate vesting of all stock allocations and performance incentive payments as specified in original agreement terms, I replied evenly, upon involuntary termination without documented justification. More silence. Then I heard him speaking to someone else, voice muffled like he'd covered the receiver. He embedded it in the release. Yes, the entire separation package. I don't know how this wasn't caught. When he returned to the line, his voice was carefully controlled, the kind of control that comes from barely contained panic. Mr. Phillips, there appears to be some confusion regarding the documents. We'd like to arrange a meeting to discuss this situation. No confusion on my end, I said pleasantly. I signed exactly what your Human Resources Department provided. The confidentiality agreement I returned during the contract review 6 months ago. The comprehensive release from your standard termination package. Everything properly executed and accepted by Apex Strategic Solutions. Cooper tried a different approach. The confidentiality agreement you signed isn't the version we distributed. That's correct, I said. It's the version I submitted and your HR department accepted, making it part of my official employment file. That's my controlling confidentiality agreement under state contract law. Your acceptance of my signed version constitutes agreement to those modifications. Mr. Phillips, Cooper said, his voice rising, losing that careful control, employees don't get to modify company documents unilaterally. They do when employers accept those modifications without review, I replied. You had 6 months to reject my confidentiality agreement. You didn't. You filed it officially. You treated it as valid. Now it's binding. I need to consult with our employment litigation team and call you back, he said quickly. Feel free, I said. My attorney Linda Martinez will be handling all subsequent communications. She specializes in employment law. Tell Eugene Parker to have his team contact Ms. Martinez directly. I disconnected the call. Barbara stared at me across the dinner table, fork suspended in midair. The company's lawyer just called you, she said slowly. Their general counsel, I corrected, taking another sip of wine. Sounds like he just discovered they owe me approximately $680,000, possibly more depending on stock valuation. Her eyes widened considerably. How is that even possible? Because my employment agreement from 2017 contains a separation package provision they forgot existed, I explained. And when they terminated me without documented justification, they triggered it. The elegant part is the release I signed includes language accepting that separation package. So by their own documentation, they acknowledge they owe it to me. Her expression shifted from shock to something like admiration. That's brilliant. That's strategic planning, I corrected. I've been preparing this for 11 weeks. At 54, you learn that corporate loyalty is a one-way street. Companies will use your experience when they need it, then discard you the moment you become expensive. But experience also teaches you how to read contracts, how to spot weaknesses, how to plan ahead. Eugene Parker thought he was getting rid of expensive dead weight. Instead, he'd just activated the most expensive severance package in company history. My phone rang again 35 minutes later. Different number. "Harold Phillips?" Linda Martinez said, her voice carrying barely suppressed excitement. "I just received a very interesting voicemail from Apex's general counsel, Arthur Cooper. Apparently, they've discovered the modifications you made to the confidentiality agreement and the cross-reference in the comprehensive release. They're in complete panic mode." "Excellent," I said. "That was the plan." She actually laughed. "Harold, this is the most elegant legal trap I've witnessed in 9 years of employment law practice. You embedded the separation package, acceptance in documents they believed were protecting them. Now they can't argue you didn't agree to termination terms without simultaneously acknowledging those terms include paying you $680,000. It's beautiful." "When do we meet with them?" I asked. "Tomorrow at 3 p.m. if you're available," she said. I cleared my afternoon the moment Cooper called. "I'm available," I replied. "Let's collect what they owe me." The meeting happened at Linda's office downtown, neutral territory. Arthur Cooper arrived with 3 associates, all looking like they'd spent the night reviewing documents and realizing exactly how badly they'd messed up. Karen Turner came looking uncomfortable. Dennis Coleman from HR sat in the corner taking notes, looking like he wanted to be anywhere else. Cooper was maybe 51, expensive suit, the bearing of someone used to winning legal arguments. But today, he looked stressed, exhausted, like he'd aged 7 years overnight. "Mr. Phillips," Cooper began, setting his briefcase on the conference table. "We've reviewed the documents you signed yesterday. There appear to be significant discrepancies between what we provided and what you executed." "No discrepancies," Linda said smoothly, opening her folder. "My client signed exactly what your HR department gave him. The confidentiality agreement he signed is the one he submitted during your contract review 6 months ago. The comprehensive release is the standard form from your termination package." Cooper pulled out his folder, the movement sharp. "The confidentiality agreement Harold signed is not the version we distributed in June. It contains additional language and modified section references." "That's correct," Linda replied, calmly. "The confidentiality agreement Harold submitted during the review cycle contained modifications. Your HR department accepted it, filed it in his personnel folder, made it the controlling agreement. If you had issues with the terms, you should have rejected his signature and required him to sign your version. You didn't. Under state contract law, acceptance of a modified document constitutes agreement to those modifications." "That's not how corporate document procedures work," Cooper said, voice rising. "It is when the employer accepts the changes," Linda said, tone still pleasant but firm. "Look at your own process. You sent confidentiality agreements to executive staff, asked them to sign and return within 3 weeks. Harold returned a signed document within that time frame. Your HR department accepted it without comparison to the original, filed it officially, treated it as valid for 6 months. You can't retroactively claim it's invalid because you didn't read it carefully." Cooper turned to Karen, expression hard. Did you review his confidentiality agreement when he submitted it? Karen looked miserable. No, she admitted quietly. We assumed executives would sign what we sent them. We didn't compare returned documents to originals. Linda smiled slightly. That's your problem, not Harold's. Your inadequate process created a valid binding agreement. Now, let's discuss the comprehensive release. Cooper pulled out another document, yellow highlighting marking the relevant passage. The release clearly states that Mr. Phillips waives all claims against Apex Strategic Solutions. It does, Linda agreed. It also clearly states in the signature section that signing constitutes acceptance of the separation package outlined in his April 2017 employment agreement. You can't have it both ways, Mr. Cooper. Either the entire document is valid, including the separation package acceptance, or the entire document is invalid, including the waiver of claims. What separation package? Karen asked, looking genuinely confused. We never offered him severance. You didn't offer it voluntarily, Linda said, but his employment agreement requires it. She pulled out a thick document. April 19, 2017. Senior Director Employment Agreement between Harold Phillips and Apex Strategic Solutions. Turn to Addendum F, Sections 4 through 9. Separation Package Provisions. Cooper flipped pages, jaw tightening. He read silently, his face progressing from confused to appalled. This contract is 7 years old, he said finally. It's still valid, Linda replied. Never amended, never superseded, still binding. Section 4 specifies that in the event of involuntary termination without documented justification, the employee is entitled to minimum 3 years base compensation. Section 5 specifies immediate vesting of all stock allocations. Section 6 requires payout of accrued vacation time. Section 7 covers performance incentive payments earned but not yet distributed. We terminated him for attitude issues, Karen said defensively. That's documented justification. Is it? Linda asked. Because state employment law requires justification be specific, objective, and documented with progressive discipline procedures. Attitude issues is vague and subjective. Where are the written warnings? Performance improvement plans, documented incidents with dates and witnesses, attempts at correction? Do you have any of that? Karen hesitated, glancing at Dennis, who shook his head slightly. No, she admitted. This was a business decision. Eugene wanted to reduce headcount in client relations. Then it's termination without documented justification, Linda said, which triggers Addendum F, which Harold accepted by signing the comprehensive release. Cooper leaned forward. The contract says minimum 3 years compensation. We can argue that's also the maximum. No, you can't, Linda replied immediately. Minimum means floor, not ceiling. At least 3 years, not at most 3 years. When you factor in immediate stock vesting, accrued vacation payout, and performance incentives, the total is significantly higher than just base salary. How much are we discussing? Cooper asked, voice tight. Linda slid a detailed spreadsheet across the table. 3 years base compensation at $145,000 annually equals $435,000. Stock allocations granted in 2017, 2019, 2021, and 2023, all vesting immediately. Current valuation $162,000. Accrued vacation time 73 days at current rate, $39,800. Performance incentive payment for this year $48,000. Total $684,800 plus statutory interest at 8% annually from termination date until paid. Every day you delay makes this more expensive. Cooper's jaw tightened until I thought his teeth might crack. We're not paying that. That's your prerogative, Linda said calmly. Then we file suit tomorrow for breach of contract. And we add wrongful termination, age discrimination given Eugene Parker's systematic replacement of employees over 45, and breach of good faith dealing. We'll be seeking the $684,800 contractual debt, plus punitive damages, plus immediate vesting of Harold's future stock allocations, plus legal fees. Our estimate for jury verdict is $1.1 million to $1.8 million plus the publicity of a trial where your CEO's age discrimination pattern gets examined in open court. The room went silent. Karen looked at Cooper with something approaching horror. Dennis stopped typing. The associates whispered to each other urgently. Cooper's expression was tight, controlled, but I could see the calculation happening behind his eyes. They'd made catastrophic errors, and fighting this would cost more than settling. Finally, Cooper said, voice carefully neutral, "We need to discuss this internally." "You have 72 hours, Linda replied. "After that, we file suit, and this becomes public record." 4 days later, Linda called. "They're offering $520,000. Final offer." "Not sufficient," I replied immediately. "We established $684,800 as the contractual minimum. Counter with the full amount plus immediate vesting of next year's stock allocations. That brings it to $795,000 total." "They'll never agree," Linda said. "Then we file tomorrow," I said. "I'm not compromising." They breached the contract. They owe what they owe. She called back 5 hours later. They've agreed to $684,800 plus immediate vesting of next year's stock allocations, but they want a broader release covering age discrimination claims. "No," I said firmly. "The release I already signed covers contract claims. If they want age discrimination specifically waived, they need to pay more. Another $85,000 and a written admission that my termination was without proper documentation. It took another 3 days of negotiations, but they gave in. Final settlement, $755,000. Written acknowledgement that my termination was without documented justification. Immediate vesting of all stock allocations. Continuation of health benefits for 18 months. Neutral reference letter. Agreement they wouldn't contest my unemployment claim. The check arrived by courier 2 weeks later. $755,000. After taxes, I netted approximately $485,000. But it wasn't really about the money. It was about 24 years of loyalty meaning nothing to Eugene Parker. It was about watching him systematically push out experienced employees to save on salaries. It was about Karen Turner calling me into that office and telling me I had attitude issues after I'd made her department successful. Within 6 weeks of my settlement, 5 other former Apex employees contacted Linda Martinez, all over 45, all terminated for vague reasons without documentation, all with employment contracts containing similar separation package clauses. Linda took all 5 cases. Within 9 months, Apex paid out another $1.3 million in settlements. The pattern was undeniable. Eugene Parker had been systematically terminating older employees to reduce costs, assuming they'd sign general releases and leave quietly. Most had done exactly that, but not me. And once my case proved the pattern, others had leverage. Apex's board started asking uncomfortable questions about why the company was hemorrhaging money in employment settlements, why legal fees were skyrocketing, why major clients were asking difficult questions about company culture. Eugene tried to blame HR for not catching the contract provisions, but the board saw through it. His cost-cutting strategy had cost the company over $2 million and damaged their reputation badly enough that 4 major clients moved to competitors. 9 months after my termination, Eugene Parker was quietly asked to resign. The official announcement said he was pursuing other opportunities. The reality was his strategy of pushing out expensive older workers had backfired catastrophically. As for me, I took 5 months off, actually relaxed for the first time in 24 years. Barbara and I took that trip to Ireland we'd been postponing for a decade. We visited Sarah at college and told her the tuition was fully covered. She could focus on her studies without worrying about student loans. That conversation alone was worth every hour I'd spent planning this strategy. Then former clients started calling. They'd heard about my departure from Apex. Wanted to know if I was available for consulting work. Within 10 months, I had more projects than I could handle. Started my own client relations consulting firm. Hired 3 of the directors Eugene Parker had fired. All over 50, all incredibly talented, all grateful for the opportunity. First-year revenue was $590,000. Second year, $920,000. All without corporate politics or fear of some CEO deciding I was too expensive. The best part wasn't the financial success, though that was satisfying. The best part was running into Karen Turner at an industry conference 14 months later. She was still at Apex, looking tired and stressed like she'd aged 5 years in 14 months. She saw me across the room and tried to avoid eye contact, pretending to be very interested in her phone. I walked over anyway. "Karen," I said pleasantly, "how's everything at Apex?" She looked uncomfortable, shifting her weight. "Fine," she said. "Busy." "I heard Eugene Parker resigned," I said. "Board thought it was time for a change?" She nodded stiffly. "Funny how that works," I said, keeping my tone. "Conversational. Fire people without proper documentation and eventually it catches up. I hope you learned something from all this. When HR tells you to just file documents without reading them, maybe read them anyway. Could save the company a lot of money." She walked away without another word. Linda and I stayed in touch. She refers employment cases to me occasionally, asking me to review contracts and identify leverage points. I've helped 14 people in the past 3 years negotiate better settlements or fight wrongful terminations. Each time, the strategy is the same. Document everything. Understand your contracts. Know your rights. When companies try to push you out, make them pay every penny they contractually owe. The phone call from Arthur Cooper asking if I'd signed the confidentiality agreement yet. That strain in his voice when he realized what I'd done. That's the sound of a company discovering that legal language matters. That employees can be just as strategic as corporate lawyers. That accepting documents without review creates binding obligations. The silence on his end when I read the language was deafening. The silence of realizing you've made a $755,000 mistake. The silence of understanding that the director you thought you quietly pushed out just became the most expensive termination in company history. Sometimes people ask if I feel guilty about the money, about costing Apex so much. The answer is no, not even slightly. They had a contract with me. They violated it by terminating me without documented justification. They paid the price specified in that contract. That's not guilt. That's accountability. At 54, I learned the most valuable lesson of my career. The moment you become expensive or inconvenient to a company, you're disposable, unless you're prepared and understand that employment contracts are negotiable documents that can protect you if you're strategic enough. But here's the deeper truth that every working man over 45 needs to understand. Loyalty without contracts is meaningless, but knowledge of your rights, combined with the patience to plan and the courage to act, can transform your biggest professional crisis into your greatest victory.